Losing a job is a deeply unsettling experience. One day you have a steady income, and the next, it can feel like the ground has disappeared from beneath your feet. To soften this blow, a federal law exists to provide a small but important cushion for many American workers. It is called the WARN Act. WARN stands for the Worker Adjustment and Retraining Notification Act. In simple terms, this law requires certain large employers to give their employees a heads up before a major layoff or a plant closure. It is a rule designed to provide a buffer, a moment to breathe and prepare for what comes next. The core idea behind the WARN Act is fairness and forewarning. Congress created this law recognizing that sudden mass job losses can devastate individuals and families, but entire communities. The act is not a guarantee that your job is safe. It is also not a form of severance pay, which is a separate issue between an employer and employee. Instead, the WARN Act is about providing time. It gives affected workers a crucial window to start looking for a new job, to explore options for retraining in a new field, or to apply for unemployment benefits before their final paycheck arrives. This notice period is a fundamental protection. For employers, understanding this law is just as critical. A failure to comply can lead to significant financial penalties. These penalties are not just fines paid to the government. They often involve paying back wages and benefits to every single employee who did not receive the proper notice. Beyond the financial cost, ignoring the WARN Act can damage a company's reputation, making it harder to attract talent in the future. The WARN Act does not apply to every company or every layoff. The law has specific criteria that determine who is covered. It is important to understand these rules. First, let's look at the employer. The law generally applies to businesses with 100 or more full-time employees. A full-time employee is typically defined as someone who works at least 20 hours a week and someone who has been with the company for at least 6 of the last 12 months. Part-time workers generally do not count toward this initial threshold. That can make the calculation complex for mixed workforces. Once an employer is large enough, the next question is what event triggers the law. The WARN Act is activated by two main scenarios. A plant closing, a mass layoff. A plant closing happens when an employer shuts down an entire single site of employment, resulting in job loss for 50 or more employees within any 30-day period. This could be a factory, an office, or any distinct operational unit. The key is the complete shutdown of a specific location and the number affected. A mass layoff is more complicated. It isn't just any large reduction in staff. It covers job loss at a single site that doesn't close completely but affects many employees. It applies when 500 or more full-time employees are laid off, or if between 50 and 499 full-time employees are laid off, and that number is at least 33% of the site's active workforce. These numbers are crucial. Falling just short may mean no coverage. Who qualifies as an affected employee matters too. The law protects most workers who lose their jobs in a covered layoff or closing, including managers and supervisors. But it typically does not cover workers on strike or those hired for a temporary project that was clearly time-limited. The details matter. Counting employees, determining workforce percentage, and identifying the layoff's timeframe are critical to knowing if WARN applies. The single most important provision of the WARN Act is the 60-day notice rule. This is the heart of the law. If an employer is covered by the Act and is planning a plant closing or a mass layoff, they must provide a written notice at least 60 calendar days before the first employee is let go. This is not a suggestion or a best practice. It is a legal requirement. The notice must be in writing. A verbal warning in a meeting or a rumor circulating through the office does not count as official notice under the law. It has to be a formal, documented communication. This 60-day window is not an arbitrary number. It was chosen to provide a reasonable amount of time for workers to adjust to the impending job loss. During this period, employees can continue to work and earn their regular pay and benefits. This stable income is vital as they begin the difficult process of searching for new employment. It gives them time to update their resumes, contact potential employers, and go on interviews without the immediate financial panic that comes with a sudden termination. This period also allows local government agencies to prepare resources, job fairs, training programs. There are, however, a few specific exceptions to this 60-day rule. These exceptions are narrowly defined and can be difficult for an employer to prove. One is the faltering company exception. This may apply if a company was actively seeking new capital or business to keep the doors open, and giving a 60-day notice would have jeopardized those efforts. Another is the unforeseeable business circumstances exception for sudden and unexpected events that cause a layoff, like the abrupt cancellation of a major contract. Finally, a natural disaster exception applies if the layoff is a direct result of a flood, earthquake, or similar catastrophe. If an employer violates the 60-day rule and does not qualify for one of these rare exceptions, the consequences are significant. The company can be required to pay each affected employee their back pay and benefits for every day of the violation, up to the full 60 days. For a company laying off hundreds of workers, this can add up to millions of dollars in liability. This penalty serves as a powerful incentive for employers to take the notice requirement seriously. It ensures that the 60-day period is not just a guideline, but an enforceable right for workers caught in a difficult situation. Knowing how it works is essential for navigating the often turbulent waters of the modern economy, whether you are signing the paychecks or receiving them. When a large-scale layoff is on the horizon, employers and employees have clear steps to navigate the process and protect their interests. For employers, the process begins with careful planning and legal consultation. The first step, determine definitively if the WARN Act applies. Accurately count all full-time employees, project the exact number of job losses over the period. If your company is close to the threshold, act as if the law applies to avoid penalties. If the WARN Act does apply, prepare and deliver the formal written notice. Send notice to the affected employees themselves or their union representative. Send notice to the state's dislocated worker unit. Send notice to the chief elected official of the local government. The notice must include the planned date of the layoff, whether it is temporary or permanent, and the job titles of the positions being eliminated. For employees, the steps are different. If you receive a layoff notice, read it very carefully. It should provide you with your official end date. If your company announces a mass layoff but you do not receive a written notice, ask Human Resources for one. Start saving all related documents immediately. Save the notice itself, save any emails from the company about the layoff, save your final pay stubs, save information about your benefits. These documents will be crucial if you need to file a claim or apply for unemployment benefits. After receiving a notice, it is time to act. Do not wait until your last day of work to begin planning your next steps. Use the 60-day period to your advantage. Update your resume. Start networking. Research companies in your field. The WARN Act is a powerful tool, but it only works if people know their rights and how to enforce them. If you believe your employer has violated the law, for instance by laying you off without the required 60-day notice, you should not stay silent. The first place to turn for information is your state's labor agency or dislocated worker unit. These government offices can provide clear, reliable information, the Federal WARN Act, similar state laws. They can help you understand if your situation is likely covered and explain the process for filing a complaint. Consider the story of a software company with 200 employees. The company lost its biggest client unexpectedly and decided to lay off 75 workers. The employees were told on a Friday that it was their last day. They received no advance written notice. In this case, the company likely violated the WARN Act. The laid-off employees, after consulting with their state labor office, could join together to file a lawsuit. A court could then order the company to pay each of those 75 employees 60 days of wages and benefits as a penalty. This is a clear example of how the law protects workers from sudden economic shocks. For employers, seeking legal advice is not a sign of weakness. It is a mark of responsible leadership. Employment law is complex, and the WARN Act has many nuances. Consulting with an attorney who specializes in this area before taking any action can prevent costly mistakes. A lawyer can help you accurately calculate employee numbers, determine if an exception applies, and draft a notice that meets all legal requirements. This proactive approach protects the company from liability and ensures fairness and respect. Ultimately, the WARN Act is a reminder that employer-employee relationships come with responsibilities on both sides. If you are a worker facing a layoff, keep your records, ask questions, and seek help promptly. If you are an employer, plan carefully, communicate clearly, and treat your employees with dignity. Navigating a mass layoff is never easy, but understanding your rights and obligations is the first step toward a process that is fair for everyone involved. Information is your best ally in these challenging moments. The WARN Act is a vital piece of labor law that impacts thousands of people every year,